everybody. My name is Paul Sine with HER Realtors, licensed realtor in the states of Ohio and Kentucky. And with me today is Mike McNeil. Glad to have you on my podcast today. How are you doing today, Mike?
I'm doing well. Thanks for having me.
Well, thank you for being on our podcast. Why don't we start out with, why don't you tell us a little bit about yourself, what you do, and where do you work?
I work at Graydon Head Law. I've been there about a year, a little over a year. Prior to that, I was with a small firm downtown in Cincinnati as well. I was there 20 plus years, started there even as a summer clerk. So I've been practicing primarily domestic relations law, a little bit of probate litigation from the time I started. So
Okay. What can you tell us? Tell us what is domestic relations law? What does it involve?
domestic relations or family law is really the more generic term for that, is anything that involves divorce, dissolution, custody, both pre and post decree, and it also now involves a lot of juvenile court matters, family matters that involve people who are not married. Juvenile court is where those matters are handled.
Okay. So my main reason is with my podcast is real estate related. So we're going to kind of focus on the real estate aspects and family law. So here's a question that kind of comes up here and there. I've seen prior to marriage, a spouse, husband or wife, they bought a house and now they're married and they're planning on getting a divorce. How is the house treated in that situation?
Well, the answer to that is often the case with lawyers is it depends.
It depends, yeah.
But the starting point in Ohio for real estate as well as any other property that you acquire while you're married is the property that you acquire prior to your marriage is considered separate property under Ohio law. So, for example, if the house is titled in the spouse's name who purchased the house prior to marriage, the interest that they had in that house prior to marriage will be considered separate property.
Okay.
You will often, in that case, have a mixed asset in that you would also then perhaps acquire equity during the marriage. That's a process where you'd have to sort that out between the two elements.
Okay. So the fact of, let's say they both happen to refinance afterwards, the title's still in one spouse's name. Does the refinance on the mortgage change that any?
It can. Certainly the refinance can affect the separate property status of the home, particularly if you refinance and upgrade the amount of money that you're borrowing. If you eliminate the equity that the person brought into the marriage, then you're probably also eliminating the separate property elements. And again, it typically comes down to a matter of tracing that premarital interest. If it survives and is traceable, it's going to maintain its separate character unless you make a definitive act that would convert it into marital property.
Okay, so then it's back, basically it's joint ownership, and then, under the divorce proceedings, then the court's going to decide who gets what.
Correct. And the title to the house really is irrelevant in the eyes of the court. So regardless of whether you acquire the house before the marriage or after the marriage, if it's titled in one person's name, really isn't the determinative factor. The question is, did you acquire it before the marriage or during the marriage? And there's a marital property component. If you acquire the house during the marriage and it's only titled in one person's name, it's still marital property.
Okay. And then I know with prior to getting married, there's something that's called a prenuptial agreement. Why don't you explain to us what's a prenuptial agreement?
Prenuptial agreement in the context typically deals with two matters. One is the event of a divorce, and the other is upon your death. With respect to real estate, your question pertaining to real estate, in terms of divorce, it might spell out and define the separate character of property, as we just discussed, namely that it might define what the premarital interest in that home is. It might very well preserve that premarital interest and or preserve any additional pay down in equity or increase in value as separate property.
Okay. It
might specify that a certain portion of that home is going to become marital. So the agreement would clarify that typically. It also likely would involve a waiver of your statutory rights upon death, including your dower interest in the real estate and or any claim to it as a surviving spouse.
Okay, so anybody considering a prenup with regards to any property that's been in the family for a while, both sides should have their own attorney, correct?
Absolutely, and in fact, most lawyers would concur that in order for the prenup to have any merit and to be upheld, it's going to need to have two lawyers involved. You need to have a full disclosure of all the assets and liabilities by both parties, and you need to have an adequate amount of time to consider all of that before signing it.
Okay.
So, in other words, signing, the morning of your wedding is potentially problematic as well.
Yeah, I'm sure it is. So the prenup then can protect that one party or can actually protect both parties depending on the assets. And can you explain that a little more?
Yeah, the prenup certainly would clarify the understanding of the parties, and it could very well protect the party's premarital interest. But again, as I indicated before, your premarital interest, to the extent it's traceable, is going to be protected under Ohio law anyway. So, for example, if you've made a $50,000 down payment on the house prior to your marriage, that $50,000, to the extent it's traceable, is going to retain its character as a separate interest. The question going forward would be, what is the additional equity going to be? How's that going to be treated, marital, separate, or mixed? The premarital agreement could very well spell that out.
Okay.
So that is one potential benefit.
Okay. Well, let's talk now about somebody who's married and they've bought property together. Say they bought a home together, living in it now for a couple of years, then they decide they want to get a divorce. How is I understand that it could be amicable. They could decide, okay, the husband gets the house, the wife gets the house, or if there's a battle, how does the court determine who gets what?
Well, the court is going to determine either one or, the house is typically going to follow the parent who has custody of the children if that's in dispute, although not necessarily. It's always, again, there's a variety of factors that are considered, not the least of which are one or both spouses' ability to support the house. 20 years ago, everybody seemed to have a lot of equity in their homes, and it was a matter of getting that equity out to the spouse who wasn't keeping the home. Frankly, now you still have that, but you also have a lot of situations where the house has little or no equity, or it's upside down, and it's a matter of reconciling that in the context of a divorce. The court will do it, or of course you can do it by agreement. Bottom line is that if one party is going to keep the house, you need to either agree upon or have the court determine what it's worth, what the equity is, and how you then allocate or account for the non-retaining spouse's interest.
Okay, so it's similarly with the mortgage debts too. I mean, that they're going to look at both of that as well and kind of apportion that between the parties too.
Mortgage debt is going to be resolved typically one of two ways, which is that the house is going to be sold, and to the extent the mortgage wouldn't be paid off at sale, the parties would typically contribute equally, although, again, the court can order a disproportionate allocation if that suits the situation. Otherwise, if one spouse is going to keep the house, they're likely going to be required to refinance the property to get the other party's name off the mortgage.
Okay, so that's generally a court requirement.
It's a court requirement. It's typically a requirement of settlement. You can agree in settlement otherwise, but needless to say, that's going to impair the ability of the non-retaining spouse to get a mortgage of their own. It's not unusual to extend some period of time out into the future to allow that spouse to refinance, and depending again on the circumstances, that may be anywhere from 3 months to years, depending on the arrangement, particularly if they're trying to maintain a home for children.
Okay. And now are there situations where one spouse says you can have the house and they don't deal with the mortgage? I mean, what happens in that situation if suddenly the one spouse isn't paying the mortgage payments, they're going to come after both of them, correct?
Yes, that's correct. Your divorce decree doesn't alter your relationship with the bank. So the bank is going to treat you both as being responsible for the mortgage. Your divorce decree may very well have terms in it that require the retaining spouse to hold you harmless, which would involve the contempt proceeding. But at the end of the day, if the mortgage isn't being paid, the bank can pursue both of you to recover. Ultimately, that's likely to result in the house being sold or listed for.
Now let's say we got a married couple. They're in the process of divorce. They're not finalized yet, and one wants to, maybe they were living in a house before or living in an apartment, and now one wants to buy a house. How do they protect themselves prior to the divorce decree being finalized?
Well, ideally what you would do is do that with the consent of the other spouse, who would waive their claims and waive their dower rights, etc., in the property, with an agreement that the purchase is going to be separate property in anticipation of the divorce. To the extent you wouldn't have an agreement, you could potentially buy that through a straw man or a trust. But frankly, in the context of a divorce, you have to disclose all that anyway. It's best to sort that out in advance by agreement. Typically, it makes sense for the non-buying spouse to go along with that. But there are certainly circumstances where they won't.
Yeah, and in the event they don't do that, what is that you just kind of have to wait it out?
You may have to wait, or you can ask the court to intervene and render an order accordingly. The problem with that is that in the context of a real estate purchase, that may not be done in a timely manner to satisfy the seller.
That's true. Yeah, real estate transactions can take some time. So in the divorce process, the court wants to sell a home. Who's going to be the determiner of the valuation? Who's going to say, okay, the house is worth this, and this is how we'll divide it, and then you two can sell it and go your separate ways?
Well, ideally, the parties will agree on a sale price. I would typically recommend that they contact a realtor. Ideally, again, you're involved with a realtor that both parties are comfortable with, but the realtor can provide you, at the very least, an initial assessment of the value of the house, what it would list for, what it would likely sell for.
Okay.
If you have reasonable parties, typically that's enough for a starting point, short of a formal appraisal. Otherwise, the court may require a formal appraisal, either for the case of a sale or for a determination of who's going to keep the house and what the equity is. But the formal appraisal process, frankly, isn't necessarily a great indicator of market value. And if you're going to sell it, I think generally going to a realtor is the best place to start.
Okay, and then with the court in that case, are they appointing? Is there like a court-appointed appraiser? Or how are they doing that?
They do have an approved list of appraisers, but again, you can agree on appraiser. Otherwise, it's always best if the parties can agree, much like I've said about agreeing on a realtor. And then ultimately, what will happen is you can spell out the terms of how that's going to occur, but if the house is going to be sold, the court will also retain jurisdiction to oversee the sale, so that, for example, if you have an offer of that's below the list price and one party wants to take it and the other doesn't, then the court can retain jurisdiction. Again, absent agreement that you have certain parameters that you're going to work within that would get it sold.
Okay. All right. Well, thanks. That's all the questions I have for you today, Mike. Thanks for being on the podcast. Why don't you let the audience know how they can get in touch with you?
They can call me directly at Graydon Head. My direct line is 513-629-2729, or by email, which is mmcneil@graydon.com. McNeil is MMCNEIL @graydon.com. GRAYDON.com.
Okay. Well, great. Thanks again.
Thank you, Paul.